my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we are continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times we have questions regarding service. When you start a case, you get your papers back from the court, you've got to serve them or somehow get the papers into the hands of the other person in some way. Could be by use of a bailiff. Could be by use of a court officer. Could be by certified mail. Here at the office, when the situation supports it, we'll have the other side just come and pick them up. Some relationships don't support that level of cooperation. What if, speaking of cooperation, you don't have the cooperation? What if the other side is evading service? Meaning that you're sending a bailiff to the house, the bailiff reports back that they are at the right house, there's somebody inside as they peer through the window that meets the description, he or she simply will not come to the door. Or you come to the front door and all of a sudden you see somebody run out the back and the car squeals away. How long do you have to wait before putting in motion a different method? How long do you have to wait until you can ask the court for some alternative relief? Are you stuck because the other side won't cooperate? Well, of course not. The court rules do require that we make some effort to actually hand the person the papers. That's the best way to serve someone. That way they can open up the papers, they can see what you're asking, they can participate in the litigation, and the likelihood that it'll be fair in result is much greater. However, if they choose to evade service, you're not obligated to wait forever. What will happen is the process server will try a couple times to serve them, and then they will issue an affidavit and a report. And the report will say, on these days, I tried to serve this person, I went to the right house, I verified the address, I saw a person inside, I heard them run out the door, they matched the description, they are actively evading service. With that affidavit, your lawyer will file a motion for alternative service. They will ask the court to give another method because the best method of service isn't working. More specifically, what it really means is the best method of service the other side isn't interested in. If they really wanted to participate in this, they'd just take the papers. But somehow in their head they think that if they don't take them, it'll never happen. That's not true. So the best method won't work. Then we go to alternative methods. What does that mean? We publish in the legal news that so-and-so is being sued. Perhaps you've seen publications where they're posted somewhere, it'll say on such and such date a lawsuit was filed, blah, 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 and it'll post in the legal news to an attention so-and-so is being served. It's somewhat of a fiction because people don't read the legal news. Lawyers don't read the legal news. So, publishing in the legal news is the acceptable method, but between me and you, I don't know if that actually provides notice to anybody, but that's what the rules require. You publish it in the legal news, the court may require you to post it in multiple public places, may require you to tack it on the person's door. Some alternative means, but once you do whatever means the court tells you to do, be it publication, posting, or maybe even by electronic means, by email or something, once you've done that, the court will say, all right, file a proof of service that you've done what we've asked, and once you do that, the court will invite you to file a request for a default. And the court will enter a default if it finds that you've done what is necessary to try and serve the person. And then your judgment will proceed by method of default judgment. If you have any questions about that, reach out. We'll be glad to help you out.